Well, good afternoon, folks, and thank you for joining me. My name is Michael Gault. I'm an eminent domain attorney with the Bell Carrington Price and Gregg Eminent Domain Practice Group. We like to, as part of our practice, offer these virtual town halls once every couple of weeks to projects that are important to us and projects that are soon to be in the public eye and that right-of-way acquisition is likely to be undergoing soon. So if you're here with us today, you know that we're here to talk specifically about a new interchange along I-75 at or near Bethlehem Road. This interchange project includes a number of aspects. Primarily, the first and most important aspect is that they are intending to construct a brand new interchange along I-75 between the Bill Gardner Parkway and State Road 155 in Henry County. In conjunction with that new interchange, they will be realigning a segment of Bethlehem Road, constructing new bridges across I-75, adding roundabouts, and providing additional access points to provide for future growth and expansion. Now, oftentimes we hear about these projects in our eminent domain practice, and we think that, sure, maybe this area is growing, and certainly projects like this are needed for safety or for development or otherwise. And most often we see that that is the case. The projects are well utilized, well thought out. Unfortunately, for a number of you landowners, particularly if you received one of our mailers and are here for this, it means that we have reason to believe that your property may be impacted. So unfortunately, what happens is some landowners are impacted. Their private property rights are impacted for the greater public good. Now, unfortunately for you landowners that are impacted, that is a right that the government has. In this case, a right that GDOT has. They have the right and the power for eminent domain, which just basically means that they have the right to take private property for a public purpose. And in some cases, for between 20 and 30 landowners on this particular project, that will be the case. Now, those impacts vary widely. We see oftentimes what we call strip takes, which is a small piece of frontage that is taken as an existing roadway is widened. But because we're dealing with a completely new interchange as part of this project, we would expect for there to be some more significant impacts. For vacant parcels, there could be wide swaths that are taken or parcels that are bisected or cut in half. For existing developed parcels, there could be some what we call total takes, meaning that the impact is so significant that the existing improvements or structures may be impacted such that they can't exist there anymore. And there are any number of potential impacts in between those two ends of the spectrum. But at Bell Carrington, what we do is have a practice of representing landowners in these processes from start to finish to make sure that your rights as a landowner are protected. We know that the government has rights, but what are your rights as a landowner? Well, the first and most important is the right to just compensation. Sure, oftentimes landowners like to think, well, I can stop the government. If I don't want this road to come through, I'll just fight them in court. I'll play the long game. I'll delay it for as long as possible. Unfortunately, that's not the reality of the situation. In Georgia, the DOT has the right to file condemnation in a case like this if they're unable to reach an agreement with the landowner relatively early on. And what that means is that as long as the public purpose doctrine is satisfied, meaning that the government can prove that their purpose behind any project or any taking is for the good of the public, the betterment of the public, certainly like an infrastructure or a road project would be, then they can proceed with condemnation. And then the only question that a landowner is left fighting for or arguing over or negotiating about is, what is the amount of just compensation owed? Or basically, how much will the government have to pay you? Even though the government has the right to take the property, they have to pay you the fair and adequate value for the real estate that they are acquiring from you. Now, that calculation and that analyzation is never easy. And that's really where our team comes in. The government, in this case, GDOT, will say, okay, we're going to either appraise your property or otherwise make you an offer for what we believe is the fair market value of the property that we're taking from you. But oftentimes that offer misses the mark. Sometimes it doesn't account for rising property values in an area or a unique impact to an existing business, say. In a residential case, it may not account for what we call proximity damages or damages to the remainder of the home in the after the construction is complete. We have to make sure to look at and analyze how much closer the roadway may be coming to the home. Does that provide increased noise pollution, decreased safety? All of those things go into an ultimate decrease in overall value of the home should you try to sell it after this project is complete. But your bite at the apple to reclaim those damages is now during this initial acquisition phase. You can't, as a landowner, just say, okay, I'll settle for the number that you offer me, wait a few years for the project to be complete, and then see something that you didn't realize would be a damage and try to go back for it then. It's too late at that point. You're left holding the ball. And so it's important through this process to make sure that you have somebody in your corner as a landowner, if your property is industrial, commercial, or residential, to make sure that the impacts are properly identified, number one, and number two, that they're properly valued. Now, even after those impacts are properly valued, it doesn't mean that the government's just going to write you a check and say, okay, Mr. Landowner, you're right. Oftentimes there's a significant negotiation that takes place between attorneys or landowners and representatives of the Department of Transportation. And then at some point, if those negotiations are unsuccessful, the case, like I mentioned, moves into condemnation, which is a legal proceeding. Lawyers get involved on behalf of the Georgia Department of Transportation. And if you don't have somebody representing you, then you'll be up, pro se is what we call it, representing yourself against a lawyer who knows and does this and who is familiar with this project and this procedure and does it all the time, every day of the week. And so, I think whether you call our firm or another firm like ours or contact your local attorney who can point you in the right direction, make sure that you get somebody who works in eminent domain, who deals with condemnation, who knows the process and the procedure, and who can identify the impact to your property and the value of the impact to your property. Otherwise, it's easy to get caught up in signing something quickly or agreeing to something that you maybe shouldn't. A couple of things that I like to close these town halls with. It's very easy for me to throw a lot of generic information at you. It is very difficult, nearly impossible for me to talk about particular impacts during these town halls. We can't really give legal advice during these town halls, but we can give you some general advice about the project and provide you with ways to contact us so that I can potentially engage with you, give you legal advice, but I can certainly use our system, our software, to identify your property in a few minutes while we're on the phone during an initial consultation. I can pull up your property. I can see a project overlay, which lets me know exactly what the impact to your property is. We update that constantly based on feedback that we receive from publicly available information and mapping from the Georgia Department of Transportation. I'm able to look into some documents that we also receive through that same process to tell you where I think you may stand in the timeline. I can give you an idea of what I think the actual impact to your property may be, and ultimately give you a ballpark of what I think the value of those impacts to your property may be. And so it's important to reach out to us and have that consultation. I can guarantee you very little in this process, but what I can say is that those initial consultations are always free. There are always no obligation with our firm. We're not going to charge you a consultation fee or an hourly rate or a retainer based on those consultations. We enjoy speaking with you. I'm going to enter my name, my email, and our team's website into the chat box in just a second so that you'll have a number of ways of reaching out to us to schedule those initial consultations at your convenience. We have somebody standing by ready to chat. The second thing is that oftentimes landowners are scared to hire lawyers or hesitant to hire lawyers because of the stigma or theory about outrageous attorney's fees. What we do at Bell Carrington in our eminent domain practice is unique in a fee structure in that we don't charge you upfront, out of pocket. We don't charge you hourly rates. We don't charge you retainer fees. Instead, our fee is based on a contingency fee of the amount of just compensation that we're able to recover for each landowner. And that fee is not payable or due until the case is either settled or until we reach a verdict at trial, which is your ultimate remedy as a landowner in these cases. So you don't have to worry about being on the hook or paying more money out of pocket to a lawyer than you would receive otherwise. Now, those percentages do vary some, and the nature of the percentages changes depending on the type of property. in some cases. And so it's important to reach out to us individually at the information that I'm going to provide to find out more about how those fee structures work. We can tell you quickly what the percentage looks like, how it's calculated. When it starts being calculated, it's not calculated on the total offer, but usually calculated on an increase that we're able to recover for our landowners over and above the initial offer. And so it's oftentimes a win-win for landowners in cases like this to not only have representation in their corner that knows this process and knows this procedure from start to finish, but can also help them maximize and truly recover what is the actual damage to the value of their property as a result of a road project like this. So the key takeaways are that this intersection improvement project, interchange improvement project is coming. New roads are going to be built. Existing roads are going to be improved. Certain roads are going to be realigned. And with that will come impacts to private property. Those impacts can range from fairly minimal to very significant. And depending on where you fall on that spectrum, it's important for you to reach out to our firm to find out exactly what the impact to your property is so that we can help you identify the impact, identify the value to your property from that impact, and then go to bat for you against the Georgia Department of Transportation to recover what is true, ultimate, just compensation at the end of the day. Again, Michael Gault with Bell Carrington. I'm the practice group leader with our eminent domain team, and I will enter our email address, my name, and my email. Please don't hesitate to reach out to me directly or at bellcarringtoneminentdomain.com. You can find a number of ways of reaching our team, either through scheduling appointments online, filling out fillable forms, sending us your information for us to call you, our phone number and our emails, obviously. So a number of ways for you to reach us at your convenience. Michael Gault with Bell Carrington. I want to thank you for your time and joining me, and I look forward to hearing from some of you soon. Thanks.